Okay, so, like I mentioned earlier, the Donald Trump campaign filed lawsuits in Pennsylvania to try and get, and I'm not kidding, they want to throw out all the mail-in ballots. They want to throw out like 7 million votes or something like that. I don't remember the exact number. It's very high. This document mentions it. So, this got all the way to the Pennsylvania Supreme Court. They threw it out. This is the official ruling. Let's see what it has to say. Free, fair... Oh, let me turn off the music. Sorry about that. There we go. Free, fair elections are the lifeblood of our democracy. Charges of unfairness are serious, but calling an election unfair does not make it so. Charges require specific allegations and proof. We have neither here. The Trump presidential campaign asserts that Pennsylvania's 2020 election was unfair, but as lawyer Rudolph Giuliani stressed, the campaign, quote, doesn't plead fraud. This is not a fraud case. Instead, it objects that Pennsylvania's Secretary of State and some counties restrict poll watchers and let voters fix technical defects in their mail-in ballots. It offers nothing more. Zombie Tomcat, thank you for subscribing with a 5-month streak. This case is not about whether these claims are true. Rather, the campaign appeals on a very narrow ground, whether the district court abuses its discretion in not letting the campaign amend its complaint a second time. It did not. Most of the claims in the Second Amendment complaint boil down to an issue of state law, but Pennsylvania law is willing to overlook many technical defects. It favors counting votes as long as there is no fraud. Indeed, the campaign has already litigated and lost many of those issues in state courts. The campaign tries to repackage these lawsuit claims as unconstitutional discrimination, yet its allegations are vague and conclusory. It never alleges that anyone treated the Trump campaign or Trump voters worse than it treated the Biden campaign or Biden voters, and the federal law does not require poll watchers or specify how they may observe. It also says nothing about curing technical state law errors in ballots. Each of these defects is fatal, and the proposed Second Amendment complaint does not fix them. So the district court properly denied leave to amend again. So what's being said here, Harry K5 with 20 bits, they're suddenly concerned about electronic voting now. I mean, I support paper ballots all the way, and at least machines should be vote counting only, but at least I've been consistent on it. Yeah, Republicans have no consistency. They say whatever they think is beneficial to them at the time. They don't have any, like, morals. They just have the want to win. It's disgusting. So what's being said here by the court is basically saying, the Trump lawsuits, initially when they were in the lower courts in Pennsylvania, were not about fraud. They never alleged fraud because they know that there was no fraud, and they know that they can't back up any claims of fraud in court. If you go to court and you lie, if you go to court and you say, I think there was fraud, and there's no evidence of fraud, and you're not providing any evidence of fraud, you can get in trouble for doing that. If you're a lawyer and you're saying there's fraud and there's absolutely no evidence of fraud, you might get disbarred, right? You can't just bring up frivolous lawsuits with absolutely no backing to the courts. Claire the Ag, thank you for subscribing with a 6-month streak. Thanks for the great content. Thanks for being a great viewer. So, anyway, the court cases are saying they're not alleging fraud because they're not. Even though publicly and in the court of public opinion, Trump is like, fraud, 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 it's all fraud, there's fraud. Even Giuliani in public is claiming fraud, 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 it's all fraud. In the courtroom, they're not saying this because they recognize that they will get in trouble for lying in the court of law as opposed to the court of public opinion. So, they're not alleging fraud. What are they alleging? They're alleging that constitutionally, they were disenfranchised by not allowing watchers into the place where the votes were being counted, which isn't true in the first place, by the way. There were both Republican and Democrats in the room, but they're claiming that the distances and stuff were not adequate for their purposes. The judge here is saying that within Pennsylvania law, it's not even required that there are partisan poll watchers here to count the votes, or to watch people count the votes, rather. So all those claims fall flat on their face, right? Also in terms of curing ballots is like, let's say you do a mail-in vote and the signature on your mail-in vote doesn't match the signature on your voter registration. So they're like, oh, this is kind of fishy. They contact you and they say, hey, would you come down to the place so we can cure your ballot? Basically, they're just making sure that it was you who casted the vote. That's fine. That's something that is allowed. The Trump campaign is claiming the Mightiest Quinn. Thank you for raiding with 4 raiders. Everyone go check out the Mightiest Quinn. Do we have the Quinity? Or is the Mightiest Quinn the only Quinn here? I guess I didn't notice. Anyway, so the Trump campaign is saying, oh, curing ballots is unconstitutional. It's not. But even so, this specific court case isn't even about the evidence as much as it's about the Trump campaign filed this lawsuit, and then they refiled it, and then they wanted to refile it again, amending it. You can amend lawsuits. The court has struck down their ability to amend this lawsuit because it's clear that they're just going to try and push this through time and time again and amend little things to try and get things to work. And the Supreme Court said, like, no, you're not even alleging anything important. You're wasting the court's time. Stop it. Going on, it says, nor does the campaign deserve an injunction to undo Pennsylvania's certification in its votes. The campaign's claim have no merit. The number of ballots it specifically challenge is far smaller than the roughly 81,000 vote margin of victory, and it never claims fraud or that any votes were cast by illegal voters. Plus, tossing out millions of mail-in ballots would be drastic and unprecedented. Disenfranchising a swath of votes... disenfranchising a huge swath of the electorate and upsetting all down-ballot races, too. That remedy would be grossly disproportionate to the procedural challenges raised. So we deny the motion for an injunction pending appeal. So the Trump campaign basically said, okay, because of these procedural issues, we think that all the mail-in votes should be thrown out. This is millions of votes. The Trump campaign is saying, our people who are in the polling counting place, even though they didn't have to legally be there, they didn't get to be close enough. So you need to disenfranchise millions of Pennsylvania voters. It's the most ridiculous argument ever. You cannot just say, I didn't like how this thing was done, so you have to throw out millions of votes. You can't do that. It's not how it works. The United States, its core principles are about its democracy, right? About the will of the people being heard by those in power and being able to control, government through representation in that government. To try and subvert the will of the people in order to overturn the results of a democratic election is unfucking American. I'm not even like a nationalist, and I think that's disgusting. To say, like, oh, we don't like the results of the election, so we're going to throw out the results and just install a dictator. That's repugnant. That's fascist. That's evil. I'm very iffy on the concept of evil, right? Like, are wrongdoings ever enough to literally be considered evil by definition? I don't know. But this is fucking evil. Right? I can't define evil for you, but I know it when I see it, right? Adolf Hitler, fucking evil. Stalin, evil. North Korea, evil. Trying to overturn democracy, evil. Logarth with 20 bits. Anathema. Anathema. I don't know what that means. Anathema device. Don't know what that means. Someone's gonna have to explain. Tiger White 94, 20 bits. What I find most annoying about all this is that the scum fucks like Rudy Giuliani will never suffer any repercussions for this. He'll get pardoned by Trump before it ever goes to trial, and he'll go back on Fox News. Yeah, it's gonna be bad. Anathema. 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 Have I read what citizens did to Mussolini's body after he died? Pretty hardcore stuff? No.
There's nothing funny about
Nath Ama. Insert Mermaid Man evil quote here. Yeah. Pennsylvania election law. In Pennsylvania, each county runs its own elections. 25 Pennsylvania Statute 2641A. Counties choose and staff polling places 2642B and D. They buy their own ballot boxes and voting booths and machines 2642C. They even count the votes and post The results, 2642K. In all this, counties must follow Pennsylvania's election code and regulations, but counties can and do adopt rules and guidance for election offices and electors, 2642F, and they are charged with ensuring that elections are honest, efficient, and uniformly conducted. MMO Addicted with 20 bits. Careful, calling Stalin evil can get you jumped on in some lefty circles. I've been banned from 2 Reddits now for arguing with tankies. Fuck tankies. I don't care what tankies think. Antipodians quoted 50 bits. I've recently been considering the wise words of Sebastian the Crab a lot. The United States. It's a mess. When did Sebastian say that? What? I guess I haven't seen Little Mermaid recently. Poll watchers and representatives. Counties must admit qualified poll watchers to observe votes being tallied. 25 Pennsylvania Statute 2650A. Poll watchers must be registered to vote in the county where they serve. Each candidate can pick 2 poll watchers per election district, each political party. 2687A. The poll watchers remain at the polling places while election officials count in-person ballots. Did I miss something? Tucker White 94 20 bits says still the bits leader, bitches. The poll watchers remain at the polling places while elected officials count in-person ballots. They can ask to check voting lists, and they get to be present when officials open and count the mail-in ballots. Likewise, candidates and political parties' representatives may be present when absentee and mail-in ballots are inspected, opened, or counted, or when provisional ballots are examined. Defining provisional ballots as those cast by voters whose voter registrations cannot be verified right away. Still, counties have some control over the poll watchers and representatives. Sorry, I was wrong. They do allow for poll watchers within the law. I think it just doesn't say the distance and specificity about where they need to be when they are there. It just says they need to be present. It doesn't say they need to be, within a certain distance. That's my bad. The election code does not tell counties how they must accommodate them. Counties need only allow them in the polling place or in the room where ballots are inspected, opened, or counted. And then there's some citations. Counties are expected to set up an enclosed space for vote counters at the polling place, and poll watchers shall remain outside the enclosed space. So the counties decide where the watchers stand and how close they get to the vote counters. Mail-in ballots. For decades, Pennsylvania let only certain people like members of the military and families vote by mail. But last year, as part of a bipartisan election reform, Pennsylvania expanded mail-in voting. Now, any Pennsylvania voter can vote by mail for any reason. To vote by mail, a Pennsylvania voter must take several steps. First, he or she must ask the state, Commonwealth, or his county for a mail-in ballot. To do that, he must submit a signed application with his name, date of birth, address, and other information. He must also provide a driver's license number, the last 4 digits of his social security number, and the like. Once the application is correct and complete, the county will approve it. Close to the election, the county will mail the voter a mail-in voting package. The package has a ballot and 2 envelopes. The smaller envelope, also called the secrecy envelope, is stamped official election ballot. The larger envelope is stamped with the County Board of Elections name and address and bears a printed voter declaration. Next, the voter fills out the ballot. He then folds the ballot, puts it in the first small secrecy envelope, and seals it. After that, he puts the secrecy envelope inside the larger envelope and seals that too. He must also, quote, fill out, date, and sign the declaration printed on the outside of the larger envelope. The declaration for November 2020 election reads thus: I hereby declare that I am qualified to vote for the below stated address at this election, that I have not already voted in this election, and I further declare that I marked my ballot in secret. I am qualified to vote in the enclosed ballot. I understand I am no longer eligible to vote at my polling place after I return my voted ballot. However, if my ballot is not received by the county, I understand I may only vote by provisional ballot at my polling place unless I surrender my ballot materials to be voided to the judge of elections at my polling place. And then there's the signature line and everything. Once the voter assembles the ballot packet, he can mail it back or deliver it in person. Not every voter can be expected to follow this process safely. Some forget one of the envelopes, others forget to sign the dotted line. Some major errors will invalidate a ballot. For instance, counties may not count mail-in ballots that lack secrecy envelopes. Pennsylvania Dem Party versus Bookvar. But the election code says nothing about what should happen if a county notices these errors before election day. Some counties stay silent and do not count the ballots. Others contact the voters and give them a chance to correct their errors. My ballot required a witness and signature. Oh, okay, that's interesting. I didn't know that. Facts and procedural history. On appeal from the dismissal of a complaint, we take the factual allegations as true. 1. Mail-in voting. For months, Pennsylvanians went to the polls, so to speak. The first batch of mail-in ballots went to the voters in late September. As they trickled back in, election officials noticed that some voters had not followed the rules. Some ballots were not in secrecy envelopes, so the packages were lighter and thinner than complete ballot packages. Others had declarations that voters had not completed. Some counties did not notify voters about these defective ballots. Others, including the counties named in this suit, decided to reach out to these voters to let them cure their mistakes by voting provisionally on election day or by asking for replacement ballots. I got some bits I gotta read. Harry K5 with 20 bits. The real reason R's hate mass mail-ins is because their normal vote suppression methods are canceled by it. Watch them try to make mail-in voting harder in the states where they control the governorship and legislatures. Watch them also try to make it so that mail-ins are counted by midnight election day. Yeah, it's ridiculous. It's so blatant. Tucker White 94, 20 bits. My mail-in ballot required me to say Beetlejuice 3 times and give the county my firstborn son. And then Logarth with 50 bits. Sorry for the confusion. I was saying that attacking a democratic election was, oh god, I'm already gonna mispronounce this, was, anathema to a government that is run by the will of the people. Anathema is something detested, excommunicated, or banned from. Well, that's not a word I'm gonna pick up, because I can't even pronounce it. Election day. Though more than 2 million Pennsylvanians voted by mail, even more voted in person. On election day, God, what is wrong with these headphones right now? These headphones are doing a thing where it's like echoing my, it's echoing my speech back to me, but like it's, I don't know how to describe it. It's hard to describe. It's doing a very, very annoying thing that's hurting my ears. Anathema. Okay. Don't ask me to say it again, because I'm not gonna, because I clearly can't pronounce that without it being phonetically spelled out to me. Let's see. On Election Day, November 3rd, the campaign set up poll watchers at polling places around the Commonwealth. Appellate's election officials kept poll watchers and representatives away from where ballots were opened. Why is it doing this? Hold on, let me turn down my mic audio. Maybe if I talk, it'll not do... Okay, that's a little better. Appellate's election officials kept poll watchers and representatives away from where ballots were opened, counted, and tallied. In Philadelphia, for instance, poll watchers were kept 6 to 25 feet back from the officials. In comparison, other Republican-controlled counties did give the campaign's poll watchers and representatives full access. Nearly 7 million Pennsylvanians voted, more than a third of them by mail. As of today, former Vice President Biden leads President Trump in Pennsylvania by 81,660 votes. Wagroads 13. Anathema. Look, guys, I'm not going to get it. It's over. Pennsylvania's counties certified their election results by November 23rd certification deadline. I can't have these in my ears when I'm talking. It's doing a weird buzzing thing. The next morning, the Secretary of State, technically Secretary of the Commonwealth, certified the vote totals, and the governor signed the certification of ascertainment and sent it to the U.S.
There's nothing funny about the tools
Then there's
of
a link, basically. This lawsuit, almost a week after the election, the campaign, as well as 2 voters, sued 7 Pennsylvania counties and the Secretary of State, Kathy Boockvar. It alleged that they had violated the Due Process, Equal Protection, and Electors and Elections Clause of the U.S. Constitution by taking 2 basic actions. First, the counties, encouraged by Secretary Boockvar, identified defective mail-in ballots early and told voters how to fix them. Second, they kept poll watchers and representatives from watching officials count all ballots. See, that's much better. Can you tell I'm having an easier time reading without those in my ears? It was like echoing in like a really like buzzy way in my ear, and it was making it hard to read. Sorry. Gimpig with 100 bits. Speaking of difficult registration, due to muscular dystrophy, my hands won't open. Getting my Colorado teacher's license was monstrously complicated. Made me wish we had tracking chips. That's a shame. Fu Manchu with 50 bits. It's soft A sound. The second A is pronounced the same as an apple. Guys, stop trying to get me to pronounce this word. I'm not gonna get it, period. I'm not even gonna read your shit anymore if you're just trying to get me to pronounce this. Anathema. Anathema. Now stop fucking chatting me trying to get me to say it. Jesus Christ. Let's see.
There's nothing funny about
So far, the
tools of
campaign's filed
capitalism.
or tried to file 3 complaints. The original complaint filed November 3rd set out 6 counts plus a duplicate after Bookfar and the counties moved to dismiss. On November 15th, the campaign filed a first amended complaint as of right, dropping 4 of the 6 counts plus the duplicate, including all the counts relating to poll watchers and representatives. The campaign sought a preliminary injunction to block certifying the election results. Bookfar and the counties again moved to dismiss on November 18th. The campaign sought to file a second amended complaint, resurrecting 4 dropped claims from the original complaint and adding 3 more about how Philadelphia had blocked poll watching. The district court ended these volleys, denying leave to file a second amended complaint. Instead, it dismissed the first amended complaint with prejudice and denied the campaign's motion for a preliminary injunction as moot. So basically, they asserted all this stuff that was talked about. They made an amendment to the lawsuit, and then that amended lawsuit was dropped with prejudice. When a lawsuit is dropped with prejudice, it means that it cannot be brought up again. So like, oh boy, what would an example be?
Just briefly, chat. If you guys think that I didn't have to look up how to pronounce that word, you're mistaken. I had to look it up and then come in here.
Logarth of the 100 Bits says, sorry I said that word. You should be.
Because not a single one of your phonetic spellings meant anything to anyone. Like, it did not help whatsoever.
We commend the district court for its fast, fair, patient handling of this demanding litigation, this appeal. The campaign filed this appeal Sunday, November 22nd, and we granted its motion to expedite. The campaign filed its brief and another motion September 23rd. Opposing briefs and filings arrived the next day. We are issuing this opinion non-precedentially so we can rule by November 27th. The campaign does not challenge the district court's finding that the votes lacked standing, or the voters, rather, sorry. We do not challenge the district court's finding that the voters lack standing, so we do not consider their claims. They're saying that the original dropping of the case brought forward not by the Trump campaign, but by Republican voters that were claiming that they were disenfranchised in some way. They dropped it because they felt that the plaintiffs lacked standing to file such a suit on behalf of voters. Wing the Ultimate Nug with 20 bits and a link. Tucker White 94 with 20 bets as an example would be Vic Mignaw, I don't know what that person's last name is. Lawsuit against Monica Rial and Jamie Marchi. It was dismissed with prejudice. Sure, I don't know what lawsuit you're talking about, but if it was dismissed with prejudice, that's an example.
That's right.
Oh, and then there was a link.
Propaganda.
Anathema. 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 Anathema.
Anathema. I'm never going to use this word ever again, specifically because you people have made me hate this word. Okay? So
There's
stop.
Funny about the tools of capitalism.
You mispronounced all 3 of those names. I'm nailing pronunciations today, guys. The campaign does not challenge the district court's finding that the voters lacked standing, so we do not consider their claims. On appeal, it seeks only narrow relief. To overturn the district court's decision not to let it amend its complaint again, we address this claim in Part 2. Separately, the campaign asks us for an injunction to prevent the certified vote totals from taking effect. We address that claim in Part 3.
There's nothing funny about the
Part 2.
tools of capitalism.
District Court properly denied leave to amend the complaint again. MMO Addicted with 20 bits. Ooh, Vic the Dick. Touchy-feely with underage fans. Had the balls to sue them. Disgusting. I don't even know what you guys are talking about. I don't know anything about that lawsuit. Courts should grant leave to amend freely when justice so requires. In civil rights cases, that means granting leave unless amendment would be futile or inequitable. Giving undue delay is an example of inequity. Here, the campaign's request fails as both inequitable and futile. Legal savage is the best savage. Because it's just cold and to the point. It is dry. It is... your attempts to overturn this election are futile. Lovely. The campaign's delay was undue given its stress on needing to resolve the case by the 23rd. When the campaign was before the district court, it focused its arguments on the need to resolve the case by Pennsylvania's deadline for counties to certify their votes, Monday, November 23rd. Indeed, all 3 iterations of the complaint focused their prayers for relief on blocking the certification of vote tally. The campaign said it would get no meaningful remedy after that date. Burr in sup. Don't know what that means. That's some legal stuff that I don't know. The campaign filed its first amended complaint on November 15th, 8 days before the certification deadline. Excuse me. In response to several pending motions to dismiss, it dropped many of the challenged counts from the original complaint. It did not move to file a second amended complaint until the 18th, when its opposition to the new motions to dismiss was due, and it did not file a brief in support of that motion until Friday, November 20th. Certification was 3 days away. Tucker White 94 for 20 bits. Yeah, it was a huge story in 2019. Yeah, I don't even know who the people that the case you're talking about are, much less what the case was about. As the district court rightly noted, amending that close to the deadline would have delayed resolving the issues. True, delay alone is not enough to bar amendment, but at some point the delay will become undue, placing an unwarranted burden on the court. The campaign's motion would have done just that. It would have mooted the existing motions to dismiss and require a new briefing, possibly new oral argument, and a reasoned judicial opinion within 72 hours over a weekend. That is too much to ask, especially since the proposed Second Amendment complaint largely repealed many claims abandoned by the first one. Affirming denial of leave to amend because the new movement sought largely to replace facts, an argument that could have been pled much earlier. Having repeatedly stressed the certification deadline, we're about halfway through this. Having repeatedly stressed the certification deadline, the campaign cannot now pivot and object that the district court abused its discretion by holding the campaign to that very deadline. It did not. One of the most harsh people on the internet is Legal Eagle. Legal Eagle's great. I love Legal Eagle. Amending the complaint again would have been futile. B. The campaign focuses on critiquing the district court's decision of undue delay. Though the court properly rested on that ground, we affirm on any ground supported by the record. Another ground also supports its denial of leave to amend. It would have been futile. The campaign had to plead plausible facts, not just conclusory allegations. Plaintiffs must do more than allege conclusions. Rather, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. So basically they're saying they didn't bring us any evidence for the court to make conclusions on. They just came to us and said, you need to overturn the election. You can't do that. They came with a conclusion saying, we think that them not being allowed closer to the votes means that they were constitutionally, disenfranchised, or the voters were in some way. And the court says, well, you don't get to make that determination. If you're making that argument, you need to come with us with an argument to that end, not just say, I think this, because that's for the court to decide. You need to say, this, therefore this, therefore this, and that's our conclusion. They just went straight from, this happened, here's our conclusion, without legal backing to explain why they feel that being that far away somehow disenfranchises the voters. Did I see Styx's disgusting cooking? No, I didn't. Tucker White 94 20 bits. I don't envy the journalists who specialize in trials and legal shit. There's a shit ton of legal jargon to summarize. True. Altered Rune with 20 bits and a link. I imagine a lot of people who work in legal journalism have some background in the law, whether it's even just a pre-law program or something. I don't know. I'd imagine they have some sort of background so they understand what's going on. Oh god. Remove the word anathema from the English language. Change.org petition. Lovely. Threadbare recitals of the elements of a case of action supported by more conclusory statements do not suffice. The Second Amendment complaint does not meet Twombly and Iqbal's baseline standard of specifics. To start, note what it does not allege. Fraud. Indeed, in oral argument before the district court, campaign lawyer Rudolph Giuliani conceded that the campaign, quote, does not plead fraud. Let me repeat that. Campaign lawyer Rudolph Giuliani conceded that the campaign, quote, does not plead fraud. He reiterated, if we had alleged fraud, yes, but this is not a fraud case. Quote, if we had alleged fraud, yes, but this is not a fraud case. Glad we cleared that up. Tucker White 94, 20 bits. Forget, quote, get Hannah to say cheese and her Hot Pockets, getting her to say, oh god, I already lost the pronunciation. Anathema should take its place on Tinfoil Tuesday Bingo. There we go. I hate that word now. You made me hate a word I didn't even know before today. I hate it. Though it alleges many conclusions, the Second Amendment complaint is light on facts. Take the nearly identical paragraphs introducing Count 1, 2, 4, and 6. Democrats who controlled the defendant county election boards engaged in a deliberate scheme of intentional and purposeful discrimination. Sorry, I should have said quote. This is the allegations made by the Trump campaign, not the conclusions of the court. By excluding Republican and Trump campaign observers from the canvassing of the mail ballots in order to conceal their decision not to enforce certain ballot requirements, end quote. That is conclusory. So is the claim that, upon information and belief of substantial portion of the approximately 1.5 million absentee ballots in defendant county should not have been counted. Upon information and belief is a lawyerly way of saying that the campaign does not know that something is a fact, but just suspects it or has heard it. While legal conclusions can provide the framework of a complaint, they must be supported by factual allegations, yet the campaign offers no specific facts to back up these claims. I can't even be clear. I can't be clearer than this law document. It's beautiful, and I love it. 2. The campaign has already litigated and lost most of these issues. Many of the Second Amendment complaints claims have already had their day in court. The campaign cannot use this lawsuit to collaterally attack those prior rulings. On counts 1, 2, 4, and 6, the campaign has already litigated whether ballots that lack a handwritten name, address, or date on the outer envelope must be disqualified. See in Canvass of Absentee and Mail Ballots 2020. You know, it's another lawsuit they did. The Pennsylvania Supreme Court ruled against the campaign, holding, quote, the election code does not require the Board of Elections to disqualify mail-in or absentee ballots submitted by qualified electors who signed the declaration on their ballot's outer envelope, but did not handwrite their name, their address, and or date, where no fraud or irregularity has been alleged. That holding undermines the campaign's suggestion that defective ballots should not have been counted. Counts 1 and 2 also challenge the requirements that poll watchers be registered electors of the county they wish to observe and that observers be Pennsylvania lawyers. But the federal district court has already held, quote, that the county residency requirement for poll watching does not, as applied to this particular circumstances of this election, burden any of the campaign's fundamental constitutional rights. So they're basically saying that the Trump campaign was alleging because you needed to be from the county that you want to count. Basically, in order to be a poll watcher and go and watch the votes be counted, you need to be a resident of the county that you want to watch the votes be counted in. Republicans, or very specifically the Trump campaign, was alleging that is violating our constitutional rights. And the court said, what the fuck are you talking about? No, it doesn't. Go away. Hoikaman, thank you for subscribing with a 5-month streak. I appreciate that. The campaign never applied the decision, so it is bound by it. Count 7 alleges the Philadelphia Board of Elections violated due process by obstructing poll watchers and representatives, but nothing in due process clause requires having the poll watchers or representatives, let alone watchers from outside a county or less than 18 feet away from the nearest table. The campaign cites no authority for these propositions, and we know of none. Ditto for notice and cure procedures. And the campaign litigated and lost that claim under the state law too. The Pennsylvania Supreme Court held that the election code requires only that the poll watchers be in the room, not that they be within any specific distance of the ballots. The campaign does not even challenge the dismissal of count 3, 5, and 9. The electors and elections clause counts. It conceded that under our recent decision, it lacks standing to pursue alleged violations of those clauses. And then another citation. Given its concession, we need not consider the issue anymore. The second amended complaint thus boils down to the equal protection claims in count 2, 4, 6, and 8. They require not violations of state law, but discrimination in applying it. Those claims fail too. Fat ginger beards. Oh wait, no, that wasn't a bits message. Sorry, the triangle threw me off because it was a triangle Illuminati sign and it looked like a bits message. Well, I'll read it anyway. Have you ever seen Santa and Karl Marx in the same place? I have not. True. The campaign never pleads that any defendant treated the Trump and Biden campaigner votes differently. A violation of equal protection clauses requires more than variation from county to county. It requires unequal treatment. It requires unequal treatment of similarly situated parties. So basically they're saying, okay, The Trump campaign is saying that because certain districts handled the election slightly differently, that the equal rights of Republican voters or whatever are somehow being trodden upon. But the court says no, because it's not only counties with Republicans and only counties with Democrats. Just because one happens to be majority one or majority the other doesn't make it that. They're saying that in order for it to be like an equal rights problem, then within the same district, they would have to be applying different rules to Republicans and Democrats, which they were not. Tucker White 94 with 20 bits. So basically these lawsuits were nothing more than pageantry. Yep, basically. A violation of the Equal Protection Clause requires more than variation. Oh, already read that. Sorry. But the campaign never pleads or alleges that anyone treated it differently from the Biden campaign. Count 1 alleges that the counties refused to credential the campaign's poll watchers or kept them behind metal barricades away from the ballots. It never alleges that other campaigns' poll watchers or representatives were treated differently. Count 2 alleges that an unnamed lawyer was able to watch all aspects of voting in York County, while poll watchers in Philadelphia were not. It also makes a claim about one Jared M. Mallow, who was able to poll watch in York County. Counts 4 and 6 allege the poll watchers George Gallanthin had no issues in Bucks County, but was barred from watching in Philadelphia. And the count 8 alleges that Philadelphia officials kept Jeremy Mercer too far away to verify the ballots were properly filled out. None of these counts allege facts showing improper vote counting, and none allege facts showing that the Trump campaign was singled out for adverse treatment. The campaign cites no authority suggesting that an actor discriminates by treating people equally while harboring a partisan motive, and we know of none. Tucker White 94, 20 bits, it just keeps going, I know. If you guys want me to move on, let me know. I can. I just, I find it interesting. But if you guys are bored, tell me. These county-to-county variations do not show discrimination. Counties may, consistent with equal protection, employ entirely different election procedures and voting systems within the single state. Even when boards of elections vary considerably in how they decide to reject ballots, those local differences in implementing statewide standards do not violate equal protection.
There's nothing funny about the
Nor
tools
does
of
Bush v.
capitalism.
Gore help the campaign. There, the Florida Supreme Court had ratified treating ballots unequally. That was because the principle it sets forth, the intent of the voter, lacked any specific standard to ensure its equal application. The lack of any standards at all empowered officials to treat ballots arbitrarily, violating equal protection. Here, by contrast, Pennsylvania's election code gives counties specific guidelines. To be sure, counties vary in implementing the guidance, but that is normal. Reasonable county-to-county variation is not discrimination. Bush v. Gore does not federalize every jot and tittle, Bush v. Gore does not federalize every jot and tittle of state election law. Tucker White 94 with 20 bits says, please do. People are saying, keep going? Okay, good. Except one person says that's enough. But a lot of people are saying, go. I'll go. I don't know if we'll do the whole thing, but we'll go for a little bit longer. The relief sought throwing out millions of votes is unprecedented. Finally, the Second Amended complaint seeks breathtaking relief, barring the Commonwealth from certifying its results or else declaring the election results defective and ordering the Pennsylvania General Assembly, not the voters, to choose Pennsylvania's presidential electors. It cites no authority for this drastic remedy. So basically, the Trump campaign wants to completely disregard the will of the voters, to completely throw out the results of a democratic election and just let the Republican legislature unilaterally decide that Trump wins Pennsylvania, even though he lost it. The closest the campaign comes to justifying the relief it seeks is citing Marks v. Stinton. But those facts were a far cry from the ones here. In Marks, the district court found that Stinson's campaign had orchestrated, quote, massive absentee ballot fraud, deception, intimidation, harassment, and forgery, quoting district court's tentative findings. It had lied to voters, deceived election officials, and forged ballots. We remanded the case, instructing that, quote, the district court should not direct the certification of candidate unless it finds on the basis of record evidence that its designated candidate would have won the election, but for wrongdoing. And that seemed likely. The Stinson campaign had gotten 600 net absentee ballot applications, roughly 1,000 minus 400 that were later rejected, more than the 461 vote margin of victory. Here, however, there is no clear evidence of massive absentee ballot fraud or forgery. On the contrary, at oral argument in district court, the campaign specifically disavowed any claim of fraud, and the margin of victory here is not nearly as close. Not 461 votes, but 81,000. So they're citing a case, a poll with literally one. Okay, no wins. Cool. We'll be done soon though, guys. Anyway, we're at the very bottom of the thing. So basically, they were citing a case where there was actual election fraud. I think I heard about this case. There was literally fraud. It was in a more local election where someone literally filled out a bunch of fake absentee ballots and put them through the mail. This was, of course, discovered because that's incredibly stupid, and even at the local level, that kind of thing gets caught immediately, which makes the claims of, like, widespread millions and millions of fake votes so ridiculous, because even when it happens on the small scale, in an election no one gives a shit about, it gets caught. You get caught doing stuff like that. So in that case, they had to overthrow the election and just redo the election, right? They didn't even, like, they didn't declare a winner. I think they just did a new election. The Trump campaign is wanting them to do that here. Not even that. They want them to just award the election to Donald Trump because they're butthurt, I guess. And the court said no. No, you can't do that. Though district courts should freely give leave to amend, they do not need to do so when an amendment would be futile, because the second amended complaint would not survive a motion to dismiss. The district court properly denied leave to file it. 3. No stay or injunction is warranted. We could stop here. Once we affirm the denial of leave to amend, the case is over. Still, for completeness, we address the campaign's emergency motion to stay the effect of certification. No stay or injunction is called for. That is savage. That he's like, we could stop here, but we gotta talk about this fucking shit. So the Trump campaign was trying to get them to either postpone or undo the certification of Pennsylvania's votes. The court is saying, no, you don't get to do that. Though the campaign styles its motion as seeking a stay or preliminary injunction, what it really wants is an injunction pending appeal, but it neither requested that from the district court during the appeal nor showed that it could not make the request as required by the federal rule of appellate procedure. That failure bars the motion. Even if we could grant relief, we would not. Injunctions pending appeal, like preliminary injunctions, are extraordinary remedies, never awarded as of right. For a stay or injunction pending appeal, the movant must show both a strong likelihood of success on the merits and 2, irreparable injury absent a stay or injunction. The first 2 factors are the most critical. After that, we also balance whether a stay or injunction will injure other interested parties. None of the 4 factors favor taking this extraordinary step. The campaign has no strong likelihood of success on the merits. Tucker White 94 20 bits. I love the "we could stop here" isn't an actual legal document. I know, it's beautiful. As discussed, the campaign cannot win this lawsuit. It conceded that it's not alleging election fraud. It has already raised and lost most of these state law issues, and it cannot re-litigate them here. It cites no federal authority regulating poll watchers or notice and cure. It alleges no specific discrimination, and it does not contest that it lacks standing under the Elections and Electors Clause. These claims cannot succeed. B. The campaign faces no irreparable harm. The campaign has not shown that denying relief will injure it upon information belief. It suspects that many of the 1.5 million mail-in ballots it challenged in counties were improperly counted. But it challenges no specific ballots. The campaign alleges only that at most 3 specific voters cast ballots that were not counted, and it never alleges that any except a lawful voter cast a vote. Of 7 counties, those notice and cure procedures are challenged. 4, including the 3 most populous, represent that they gave notice to only about 6,500 voters who sent in defective ballots packages. The campaign never disputed these numbers or alleged its own. Even if 10,000 voters got notice and cured their defective ballots, and every single one of them voted for Biden, that is less than an eighth of the margin of victory. Fucking savage. Fix MBR with 30 bits. A single page with massive font saying, "They ain't got shit," would have sufficed. Maria Horn, thank you for following, and Pseudo Sapien, thank you for hosting. I appreciate that. Plus, states are primarily responsible for running federal elections, U.S., and then the sites. Pennsylvania law has detailed mechanisms for disputing election results because the campaign can raise these issues and seek relief through state courts, and then the U.S. Supreme Court. Any harm may not be irreparable. C. The balance of equities opposes disenfranchising voters. Nor would granting relief be equitable. The campaign has already litigated and lost most of these issues as garden variety state law claims. It now tries to turn them into federal constitutional claims, but cannot. Even if it could, it has delayed bringing this suit. For instance, in Proper Count 4, it challenges giving voters notice and letting them cure ballot defects as violating equal protection. The campaign could have disputed these practices while they were happening, or during canvassing period. Instead, it waited almost a week after the election to file its original complaint, almost another week to amend it, and then another 3 days to amend it again. Its delays is inequitable, and further delay would wreak further inequity, and the campaign's charges are selective. Though Pennsylvania cast 2.6 million mail-in ballots, the campaign challenges 1.5 million of them. It cherry-picks votes cast in, quote, Democratic-heavy counties, but not those in, quote, Republican-heavy counties. Second Amendment... Oh, that's just the legal filing that was from. I apologize. Without compelling evidence of massive voter fraud, not even alleged here, we can hardly grant such a lopsided relief. Granted relief would harm millions of Pennsylvania voters, too. The campaign would have set aside 1.5 million ballots without even alleging fraud. As the deadline to certify votes has already passed, granting relief would disenfranchise those voters or sidestep the expressed will of the people. Tossing out those ballots would disrupt every down ballot race as well. There is no allegation of fraud, let alone proof, to justify harming those millions of voters as well as other candidates. D. The public interest favors counting all lawful voters' votes. Beautiful. Lastly, relief would not serve the public interest. Democracy depends on counting all lawful votes promptly and finally, not setting them aside without weighty proof. The public must have confidence that our government honors and respects their votes. What is more, throwing out those votes would conflict with Pennsylvania election law. The Pennsylvania Supreme Court has long liberally construed its election code to protect voters' right to vote, even when a ballot violates a technical requirement. Technicalities should not be used to make the right of the voter insecure. And then that's from a previous case from 1954. The court recently reiterated, quote, the election code should be liberally construed so as not to deprive electors of their right to elect a candidate of their choice. Thus, unless there is evidence of fraud, Pennsylvania law overlooks small ballot glitches and respects the expressed interest of every lawful voter. In our federalist system, we must respect Pennsylvania's approach to running elections. We will not make more of ballot technicalities than Pennsylvania itself does. Voters, not lawyers, choose the president. Ballots, not briefs, decide the election. The ballots here are governed by Pennsylvania election law. No federal law requires poll watchers or specifies where they must live or how close they may stand when votes are counted. Nor does federal law govern whether to count ballots with minor state law defectors or let voters cure those defects. Those are all issues of state law, not ones that we can hear, and earlier lawsuits have rejected those claims. This is them setting it up in case, at least based on what it looks like, because they're talking about state law so much and that this is a state matter. It seems to me they're writing it in this way so that if they try and bounce this to the Supreme Court, it's like, hey, this is a state thing. Stay the fuck out of our yard, basically.
Didn't get a hype train at some point.
Yeah. Okay. Hat.
I love you.
Love you too. This is the last page, by the way. We're almost done. A honeybee with 1,000 bitch enjoyed the show as always, Hannah. The, oh god. Anathema? Anathema of the atheists, but I had to go do some work. Pronounced anathema. Thank you. I appreciate it. And, Jakai must try. Thank you for following. Let's see.
They're calling us gay in chat.
True. Seeking to turn those state law claims into federal ones, the campaign claims discrimination, but its alchemy cannot transmute lead into gold.
Oh, fuck!
That's good. The campaign never alleges that any ballot was fraudulent or cast by an illegal voter. It never alleges that any defendant treated the Trump campaign or its votes worse than it treated the Biden campaign or its votes. Calling something discrimination does not make it so. The Second Amendment complaint still suffers from these core defects, so granting leave to amend would have been futile. And there is no basis to grant the unprecedented injunction sought here. First, for the reason already given, the campaign is unlikely to succeed on the merits. Second, it shows no irreparable harm, offering specific challenges to many fewer ballots than the roughly 81,000 vote margin of victory. Third, the campaign is responsible for its delay and repetitive litigation. Finally, the public interest strongly favors finality, counting every lawful voter's vote and not disenfranchising millions of Pennsylvania voters who voted by mail. Plus, discarding those votes would disrupt every other election on the ballot. We will thus affirm the district court's denial of leave to amend and deny an injunction pending appeal. The campaign asked for a very fast briefing schedule, and we have granted its request. Because the campaign wants us to move as fast as possible, we also deny oral argument. Basically, the campaign's like, we want this done very quickly, and the judges, this is the Pennsylvania Supreme Court, so there's multiple judges. Oh, you want it to be done quick, huh? Okay, no more oral arguments, bitch. We're done here. That's beautiful. We grant all motions to file overlength responses, to file America's briefs, and to supplement appendices. We deny all other outstanding motions as moot. This court's mandate shall issue at once. That was amazing. We should read court cases more often on here, whether they be interesting or savage, because that was some savage-ass shit.
There's nothing funny about the tools.
Good for the Pennsylvania Supreme Court. Tired Park says best bedtime story ever. It certainly is. It certainly is. Let's see. So yeah, that's the ruling from the Pennsylvania Supreme Court today. Interesting stuff. Pretty savage. If this goes to the Supreme Court nationally, then the United States Supreme Court, it'll be interesting because it's pretty final. Like, I understand that, like, the Supreme Court can disagree with state Supreme Courts, that happens, but this seems like all the allegations are basically about state level stuff that should be dealt with in the state, right? These are not federal violations. These are state laws, especially considering many of the conservative Supreme Court justices are probably going to want to be on the side of states having autonomy, more or less. Especially, like, even someone like Amy Coney Barrett, right? I feel like in service of wanting states to have leniency in what they're allowed to do for future rulings and stuff like abortion. Like, if it's like, I imagine at some point, some state, now that Amy Coney Barrett's on the bench, is probably going to try and ban abortion or do something that's very abortion banny, which will get another abortion case up to the Supreme Court, and she will want to rule in favor of the state's right to ban that thing, right? This going against the Pennsylvania Supreme Court in regard to state election law kind of goes against that ethos, but I don't know. Conservatives are hypocrites, so I'll never expect them to be consistent, but I'm just saying, if we're going for consistency, going against this ruling would be self-sabotaging for future states' autonomy type cases. Undercover Beast with 100 bits. Beautiful read, Hannah. You give? Okay. Undercover Beast with another 100 bits. Oh, you give Leonard French a run for his money. Gosh, I like my enter key. I certainly don't, because Leonard French actually has a law degree and knows what he is talking about. I just enjoy the savage parts I understand. Anyway, so